Welcome back to the Law and Crime Network. I'm Heather Hansen, and as promised, we are going to have that conversation about sexual assault and sexual harassment cases. Over the past few weeks, there has been so much in the news about these types of cases, and a lot of questions have come up. We wanted to make sure that we did our best to address them, and so we have a fabulous guest for that. We have Karen DeSoto. She is a former prosecutor, a criminal defense attorney, a law professor, and our guest today via phone. Good afternoon, Karen.
Hi, Heather.
It's so good to have you here. I want to start because I raised this issue with our audience and we had lots of people respond and lots of questions. And I want to talk about the statute of limitations for these types of cases. What is the rationale for having a statute of limitations at all? What's the reasoning behind that?
Well, because in the law we like to have finality, right? So in federal and state courtrooms, even to allow evidence into trials, there is a rule of thumb, which is 10 years. So the statute of limitation in federal and also in states is changed depending on the seriousness of the crime. So therefore, that's why we have murder with no statute of limitation in all states. And, of course, another area that's arising with a new statute of limitation, especially after the Cosby case, has been rape.
And when you bring up, it's interesting, the murder thing, I was doing some research on this over the weekend, and even with murder, which is, you know, we all think of it as being the thing where there's no statute of limitations. In some situations, it's not. You know, if it's an assault with a deadly weapon that then leads to murder, that sometimes can fall. So, you know, although we sort of talk about that in the media as being one of those with no statute of limitations, it sort of does depend on the facts. Isn't that also the case when it comes to sexual assault?
Oh, of course, because each state is different, okay? So there's a sliding scale. It can be anywhere from no statute of limitations to 3 years. Even in murder cases, different states have different definitions. So when I say the rule of thumb is no murder with first-degree cases, you also have second-degree cases. You have manslaughter, and they all have sliding scales, and each state does their own thing. However, let's take New York for an example. New York, after the Cosby case, has no statute of limitations on rape cases, but that's only for first degree. If it drops to a second degree, then it's 5 years. So you see, it's not just the type of crime, it's the degree as well. So the statute of limitations is always going to be sliding and always going to be different from state to state.
Well, and that's, when it comes to sexual assault, that is something that surprised and frustrated me, because in New York, as you said, for sexual assault, for rape, there's no statute of limitations. But if if a man forces himself upon someone in other ways, that does not have a statute. And it seems to be that there's no good reason, no good logic between having one and not the other, except for to respond to the public outcry. Do you think that that's the reason for this?
Well, no, there's more reasons to it, Heather, and obviously when this legislation is put through, there's lots of arguments on both sides, and you have the litigation bar who will come forward and say, you know, three things. One is that you need finality. Second, I can also tell you as a person who's tried rape cases, they're very difficult even when they're timely, right? So a limit really it's terrible, but resources and money is always an issue with investigations. I mean, we could talk about the backlog of rape kits and other different financial aspects of investigating in police departments. And therefore, there's a statute of limitations, and people will argue certain reasons for having it. One is finality of the law. Second is that if rape cases are so difficult even when they're timely, investigating cases that are 20, 30, 40 years old are inherently more difficult, and it's one of those questions, where do you put your resources? And I would love to tell you that sexual assault and rape is one of those areas that I think is really serious and deserves the financial backing, but if you say that to somebody whose family member or child was murdered, I think you would probably get a different answer. So it's the old age question about money and where do you put your resources, and it's a very difficult question for prosecutors and politicians and people who are victims to answer.
I want to jump to a statistic that I read about these types of cases that I thought was fascinating, and it sort of moves from the criminal to the civil. But I know that you read the same article that said that in federal cases, they did a federal judicial study, 70% of sexual harassment or sexual assault cases were dismissed in whole or in part. And it sort of goes to this idea, as you said, that these cases are hard to try and hard to prove. What can the legal system do to improve that? Or is it just inherent in a he said, she said type of situation that these cases are going to be difficult?
Well, the cases are getting dismissed because they're awfully hard to corroborate, right? So for criminal charges, obviously the civil context is very different. You can sue somebody, more probable than not is the standard, versus beyond a reasonable doubt. So even getting probable cause to have enough to file the criminal charges is difficult. But then when you have civil cases, it's a whole other story, and we can talk about lots of things that need to be improved. One of the things that keeps women silent is binding arbitration at corporations or mediations that are confidential, and people come up with a settlement, and part of the settlement is that they remain silent. Obviously, that's more difficult to put into a settlement contract if there's criminal charges, because it's illegal to contract for anything that's criminal. But it does scare most women, and not just women. There are men. I've represented men in sexual harassment and sexual assault cases or sexual contact cases. And, if there's a money settlement, people will ask for these confidentiality agreements. I guess the question, Heather, is that should we allow corporations to have binding arbitration in issues not just with sexual harassment, sexual assault, but any kind of public safety issue where there's others that may be in danger because of the actions that they want to keep confidential.
And that's a fabulous point, and it leads me, Karen, to my next point. I know that you too are trained as a mediator, and one of the things about mediations is at a mediation, everything is confidential. And so each side gets the opportunity to say a lot of things that they might not otherwise say, to give some explanations that they might not otherwise give, and there is some value in that. So how would you balance the value of confidentiality in order to speak freely and get things resolved and no longer as much closure as there can be, versus the problem that so many of these cases are never learned of and never found out about, and people aren't being protected?
Right. And Heather, I'm a big proponent of mediation. Obviously, mediation is different from arbitration in the sense that it's the two parties coming together to resolve their differences, and you have a person who's a neutral who guides them towards the resolution. Right? So in binding arbitration, you have an arbitrator who's making a decision very similar to a judge. Right? So in mediation, you have more freedom to kind of formulate what your resolution is going to be. The problem, Heather, is that in employment contracts now, binding arbitration is mandatory.
Right.
And so, therefore, the confidentiality that you're speaking of becomes more of a weapon than in mediation, where it can be used as a tool. So confidentiality, there are also many victims who are very ashamed,
right,
and they don't like to come forward. So mediation is a great way to resolve that, because there's lots of people who don't want to come forward. And you know what? There is so much pressure on young women and women in general to be successful and put up and be quiet. And then, of course, even when they do come forward, they get a lot of negative attention. You're a troublemaker. You're stirring the pot. And those are social norms that need to be changed. And one of the ways, quite frankly, at least in the corporate sense, to do that is to do away with binding arbitration that really silences voices and also prevents other women from protecting other women who may find themselves in the same spot with the same people working there doing the same type of behavior. Because one thing that I can tell you is that if a person is truly a predator, they're always a predator. They don't just do it once.
Let's talk a little bit. You brought up the fact that sometimes these victims want things to remain confidential. And I don't know if you were able to see Ali Reisman's interview on 60 Minutes last night, where she talked about her abuse at the hands of Larry Nassar, but she didn't go into details. And some people, I was watching some comments on that this morning, and some people were taking issue with that. Don't you think that that's part of the issue with these cases, that oftentimes mediations are a wonderful way for these
Right.
victims to speak out without having to go in front of the world and get into the specifics of exactly what happened to them?
Right. Well, it's interesting because there's lots of things correlated to this, to strategy. And one of the reasons why you don't want to go into details is because you want your witnesses to be able to corroborate other witnesses. So if you go public with specific details, then it's going to be much difficult to weigh the credibility of other witnesses. So that is a legal strategy, and it is also a way to ensure that each of these witnesses, each of these victims can corroborate the story, especially if they're independent and they don't know each other. If the pattern and practice is very similar, your case is stronger for a jury, and your case is also stronger whether you're doing mediation, arbitration, or anything else. And I know that that's difficult. People want to know specifics, but there are reasons for that.
And that is a fabulous point that I don't think anyone has made in any of the comments that I've seen, because we know, if I look at my numbers, more than 300 women, 130 women have filed lawsuits against Larry Nassar and or MSU, the school with which he was affiliated, and or the USA Gymnastics team. And to your point, if Allie goes on television and gets into specifics of what happened, then other women who perhaps didn't have anything happen to her could come forward and make similar allegations. So this way, it makes
Correct.
corroboration much more easy. Do you think that that's the main reason that she stayed silent on that topic?
There may be many reasons, but if she were my client, and if her reasoning for coming out is to corroborate other people's witnesses, it makes perfect sense. Right? So those people who come forward who say, well, you know what, there has to be some truth to it because this is the exact same manners and behaviors that he used. Right? So think about all of those cases. Now, with this doctor, there's another added element because a lot of these girls are underage,
Yes.
which is a whole nother statute of limitations. And also there's fiduciary duty, not only by behalf of the doctor, but if anyone had any sense, there may be more charges. And because of that, other people may be liable, and that's another reason to remain silent until there's a full investigation. And again, these witnesses, their testimony is very important. It's very substantive when you're corroborating somebody else's story and they don't know each other. That's very, very powerful information for jurors to hear.
I love when we have the opportunity to sort of explain something that people wonder about. And I know there were a lot of people wondering why she didn't get into more specifics. And so I love the fact that you were able to give an explanation, Karen. I want to talk as we wait. And just for the audience at home to know, we do know that they are heading back from lunch in the Adam Matos case. And as soon as they're live in the courtroom, I will take you straight there. But in the meantime, I do want to talk a little bit about mediation, because you and I have sort of gone back and forth and talked about it, Karen. But the specifics of what happens at mediation, I'm not sure that people understand. So why don't you tell our audience, for example, in this case against Larry Nassar and MSU and the USA Gymnastics team, there's going to be some mediation, right? We read about that. I read about that last night.
Correct.
What does that mediation?
And one of the reasons, Heather, for that is because, again, you may be dealing with underage girls, and mediation being confidential, and also giving the parties and the attorneys the tools to come up with a resolution rather than relying on an arbitrator who basically is taking the place of a judge. When you have underage girls, you want to keep them as anonymous as possible. And this may be something their parents want, and obviously this may be somebody who's underage, and I can't really fault them for that. Mediation is good in that sense, but it's also bad, Heather, because this is one of the reasons why the priests in the Catholic Church, with a lot of the cases from Boston, were able to remain silent for so many years. So there is a public safety issue to these confidentiality agreements. Now, the confidentiality agreements, that does not include criminal acts, and the parents or the child can go to the police at any time because, again, you cannot contract for criminal acts. But a lot of times people are scared, they don't want to go through the trauma, and at least the mediations are one way to try and resolve it. But again, there are very good reasons for people to come forward and make these things public, but you can't really judge a minor or a woman who doesn't want to go through that process.
Well,
it's difficult.
And I think I think the benefit of mediation as well, and just to be clear about it, when you go to a mediation, the parties are there. So if the
Yes.
girls want to be there, they'll be there, and NASSAR would arguably be there, and representatives from the school and the gymnastics. And then they sit down, and one of the benefits is that the victims, if they want to, get to say their piece and to confront their accuser, their
Right.
offender, which is wonderful. But they can also mold an agreement that says
Yes.
that they don't have to keep confidentiality if they want to, can't they?
Absolutely not. And with a lot of my sexual harassment cases, one of the reasons, even prior to getting to mediation, I make the complaint very specific because they know that it probably will settle, and they want it as a public document.
That's right.
But also in these confidentiality agreements, people who want to make it confidential, there are very specifics about, whether or not they can testify in a criminal case. They can, testify in, even Senate hearings. But also that's a little bit different, sexual harassment than sexual assault. Remember, we have criminal and we have civil, so there's other guidelines. But yes, in a mediation, you can mold your resolution any way that you want.
Yeah, and so many times we see in mediations, and one of the things that I think are so powerful about mediations is the victims might say, I want a public apology. I want him to
Yes.
come forward and do X, Y, and Z. And that's one of the things that's negotiated at the mediation, which is such a valuable piece of power to give back to these victims. Don't you find that to be helpful with the mediations?
I think it's really helpful, and I also think with mediation, depending on the serious nature, it's very difficult for a woman who's gone through a sexual assault or a rape or anyone who's been sexually harassed to actually confront the person. So at mediation, the mediator or the neutral can mold it or can strategize whatever way is more comfortable for the victim. So I may not put them together at first.
Right.
I may see each of them separate. And then I'll ask them, do you want to make a statement in front of them? Or can I go back and do I have your permission to tell them exactly what you told me? Because obviously, again, what she's telling me is confidential. And you could go back and forth like that all day. But it is a successful process because both of the parties get to agree or disagree to each of the terms. And things that are more important, that may be a public apology. It may be, anger management, or in the corporate sense, you have to go through sexual harassment training. Those type of things are more important sometimes than the money.
That's right.
And so in civil cases, money is everything, right? But in
Right.
mediations, there may be other issues that come forward.
Yeah, I've had cases fall apart at mediation. The money part is resolved and everyone's in agreement. But if the victim wants some sort of an apology or a plaque or whatever, and the
Right.
other side won't agree, the case sometimes will not resolve over those
Yes,
issues.
and that's where you hope that you have a really good mediator who can go back and forth and Heather, sometimes with mediation, there's time limits on it, and you can't go back and forth and try and craft something. But a lot of times, I'll take extra time, and I'll craft something. In this case with the doctor, he's already, pled guilty to a number
Right.
of charges. So in a case like this, I think he's already said his apologies more than once. However, you're right. In a corporate setting, with somebody who's a vice president or in administration, it's going to be more difficult because it's going to affect their reputation, and they may be thinking that, well, she's going to get a settlement and go away, and I'm going to keep my job, and therefore I don't want it ruining my reputation. So you can craft something that's a little bit neutral that may be acceptable both sides, but you're right, it takes a lot of time, and if you're doing court-appointed mediation, you only get the first 2 hours free, and then it's
Right.
expensive after that. So
It always
depends on the individual.
And so often it comes down to the almighty dollar. Karen, I want to thank you for your time and your expertise. It's nice to speak to someone who has such a wide array of criminal and civil and mediation background. I'm sure we'll be seeing you again.
Thank you, Heather.
Thank you for being on with us.